Hi folks, welcome to RJA Impact. Today we're going to be talking about week 7 in the Holmes Theranos trial. You can search this channel for previous week's updates and also for a more detailed video on the background to Theranos and Holmes' journey to the point at which this trial commenced. Please don't forget to like this video and subscribe to the channel, and also hit the notification button so that you don't miss out on any future videos. As a reminder, Elizabeth Holmes is in court accused of multiple instances of fraud against doctors, patients and investors in connection with her role as CEO of Theranos, and this is week 7 of that trial.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Before we talk about this week's witness testimony and goings on in court, we'll take a little diversion with the background section. Background bonus. Now, if you remember, on Thursday last week, we had Robert Amanta, who is an investigator at the Federal Bank of New York, and he explained how wire transfers worked. Now, if you've seen my video called Theranos, Holmes, Balwani, the full indictment, you'll have seen that 6 wire transfers are listed against counts 3 to 8 in the indictment. And as we noted in that video, the investors' names were kept anonymous. And this is the list here as we presented it straight out of the indictment. Now, as part of Amanta's testimony, the prosecution identified the actual investors, and therefore we can update the document as you can see here. Very quickly, we had Alan J. Eisman, Black Diamond Ventures, Hall Phoenix Inwood Limited, PFM Healthcare Master Fund, Lakeshore Capital Management LP, and finally Mosley Family Holdings LLC. The largest of these, the 100 million from Lakeshore Capital Management, is the one associated with the family office of the former Education Secretary, Betsy DeVos. The main substance for this week's background section will be to do a deeper dive and hone in on one of these. This is the 38 million from PFM Healthcare. Now, as well as the 38 million here, PFM Healthcare had actually invested more funds, and in total had invested $96.1 million. Now, PFM, as they like to be called, took out a lawsuit in October 2016 against Theranos, claiming that the company, its founder and CEO Elizabeth Holmes and former Chief Operating Officer Sunny Balwani engaged in quotes, a series of lies, material misstatements and omissions in order to get them to invest. They had sent a letter to their investors at the time explaining the reason for the case, and in that letter they said Theranos and its principals knowingly and repeatedly lied that they had developed proprietary technologies that worked, were on the cusp of receiving all necessary regulatory clearances and approvals, and concealed the truth about the commercial viability of their technologies and methods. They sued for the full $96.1 million plus damages. At the time, Theranos released a statement saying, in quotes, the suit is without merit, the assertions are baseless, and the plaintiff is engaging in revisionist history. Now, the lawsuit was settled in May 2017, approximately 7 months later, and the detailed terms of the settlement are confidential. However, we understand that approximately $43 million was recovered. Now, Theranos lawyers said at the time of the settlement that they were, in quotes, confident that they would have prevailed at trial. Really? You just paid $43 million when you were sure that you would prevail at court? I don't think so, buddy. So let's just follow a train of logic from here and see where it gets us. Now, the first and most obvious point to note is that the lawsuit relates to lies and misstatements, creating the desire of the VCs to invest in the company. And now these are the very things that the prosecution in the current trial are seeking to prove. Let's just observe here that this was a civil suit and the standard for winning is on a balance of probabilities, or a more likely than not approach. Now, we know that in a criminal case, like the current Holmes Balwani case, the prosecution has to prove, in quotes, beyond all reasonable doubt. So the hurdle that the prosecutors have in the current trial is a lot higher. Now, our conclusion on this is that it would seem that the company Holmes and Balwani, by settling with PFM, has at least to some extent conceded that lies and or misstatements and or omissions took place, and these were explicitly stated in this case to be by Holmes and Balwani. A small additional factoid that we found out about. While the court was full in the first couple of days of the trial and the judge made arrangements for an overflow room in the court building, since then there has been a certain dwindling of interest, and while there are still plenty of reporters, there have been days where there have been spare seats available. And finally, as well as including Thursday as a trial day, the judge has moved the court hours back an hour from 2 p.m. to 3 p.m. to help speed up the process. And so to the trial. Sunil Dhawan. We heard late Thursday and Friday last week from Sunil, who was a dermatologist brought in to be lab director for Theranos. You know, that key role that is a vital part of the company, keeping its regulatory status and licenses. He was actually an acquaintance of Bhawani, having treated him for a number of years, and he was told it would be a temporary position and that he would only work a limited number of hours. He was paid $5,000 per month for the role, and for the period from November 2014 to late 2015 spent about 5 to 10 hours performing the role. Now, the contrast between what he was asked to do and what the former lab director Rosendorf did is startling. Apparently in August or September 2015, he spent some time with the company and remembers spending hours one Saturday signing documents that were given to him just prior to a regulatory audit. I don't know about you, but this seems to us more like a dereliction of duty. How on earth could he fulfill the very demanding role of a lab director properly with the description of the duties he gave? On the signing of papers just before an audit, well, this seems like someone was shutting the stable door after the horse had bolted. Okay, but there is more to this. This was the prosecution's examination so far. When the defence undertook their cross-examination, we got quite a different flavour. We heard from them that a lady by the name of Lynette Sawyer was added to Theranos lab licence in November 2014. Yes, the same time that the company recruited Sunil for the job. Sunil said that he didn't know who she was, and also that he didn't know that she was a lab director, and apparently she was removed as a lab director in August 2015, just at the same time that Sunil was asked to come in and sign all of those papers. None of this smells right. How was an acquaintance of Bhawani put on the books to do virtually nothing for $5,000 a month and then asked to sign off key documents on a Saturday just before an audit? Clearly the defence are casting a shadow over Bhawani's role and actions in this respect. After this, there was a sidebar conversation between the judge, the defence and the prosecution when the jury had gone. Lance Wade for the defence complained that the lines of questioning were making it seem like there was a falsification of documentation going on, when, to his knowledge, there was not. The prosecution disagreed, and Judge De Villa essentially told the defence that they were being too sensitive. The defence ears are sometimes more finely tuned than others in the courtroom, he said. Daniel Edlin. Edlin came to Theranos out of college and is a key insider witness, as he also reported to Holmes for many years and was with the company both before and after the Wall Street Journal articles started to appear. Two key pieces of testimony that were covered with him on Friday were, well, firstly, that he was asked to set up mini lab devices in a room next to a lab so that touring visitors could see them, and that he was asked to curate the visitors' tours through Theranos property so that visitors could only see certain areas. He also stated that he would arrange for demonstrations of Theranos tech for board members, investors and business partners. He said that these demonstrations were set up in advance to deceive visitors. They actually had a demo machine deliberately set up to look like it was working to visitors, even if errors were actually occurring. Courtroom filings and discussions. On Tuesday, before the jury came in, we had a discussion about an internal Pfizer document and whether it should be introduced as evidence. As Holmes would never have seen it, the defence argued it should be withheld. Now, the document itself was an analysis of Theranos tech to see whether it would be beneficial for Pfizer to enter into a partnership. To put it simply, the document was not glowing. Theranos unconvincingly argues the case for having accomplished tasks of interest to Pfizer was one extract, and Theranos were oblique, deflective or evasive. The writer of the report, Dr. Webber, told Holmes that they were not interested in continuing any partnership. Now, the reason this is so key is because it's a Pfizer endorsement document that the prosecution are claiming was fabricated within Theranos endorsing their tech. Clearly, Pfizer, internally at least, from this document, were not endorsing Theranos. And back to Daniel Edlin. He testified that a demonstration lab test done in New York for a guest was undertaken both there and in California. But the tests came up with different results. The discrepancy will be a problem we need to see if we can correct for it, was included in an email written by Holmes on the matter. Edlin was asked by Daniel Young in another email to change the reference ranges, and as a result, a low-looking result would turn into a normal-looking test result. During his testimony, we heard about Theranos hiring a law firm to review their website, and in emails from them, Theranos was advised to make certain changes, including the following: ensure substantiation for the claim 1,000th the size of a typical blood draw, replace faster and easier with fast and easy, a request for substantiation for have results to you and your doctor faster than previously possible, change more precise to precise, replace highest levels of accuracy with high levels of accuracy, remove unrivaled accuracy, ensure substantiation for unprecedented speed and accuracy. Now, this was just at the time Theranos was testing patients in the Walgreens stores. Edlin said that he didn't know if the changes were made at that time. Edlin was also tasked to work on the potential military contracts and testified that machines were sent to the military for testing, but didn't know if that ever took place. A statement in a presentation to the military said that each Theranos device could run every test currently available, amongst other things. Edlin said that he had no reason to think that those aspects of the presentation weren't true, and that Holmes was highly involved in all aspects of the Defense Department relationship. Theranos devices were never used by the military, he said. Now remember that the prosecution alleged that Holmes lied to investors about Theranos having a profitable relationship with the military. Another set of exchanges with Edlin were about whether the machines would work in the higher temperatures experienced, for example, in Africa. Nope, the Edison did not have a way to cool down, Edlin said, meaning that if the machine was not between 72 Fahrenheit and 82 Fahrenheit, it would have performance problems. Holmes told Edlin that the reason that the Theranos devices were never brought by the military was because Theranos were concentrating on the Walgreens clinical launch. Edlin said that he knew about Holmes and Balwani's relationship because he had spent time in college with Holmes' brother. Critically, when asked about their relationship at work, he said he remembered times when Balwani deferred to Holmes, and that Holmes had the final decision-making authority. Did Balwani ever override Holmes? He was asked. I can't recall a specific moment, he said. The document. On Friday morning, Judge Davila ruled that the jurors would be able to see the Pfizer document during the testimony of Dr. Webber, who authorised it and made fairly damning conclusions about Theranos' capabilities and approach. It's 7 pages long and includes such lines as Theranos has been excessively pushy in accessing new points of contact once turned down by an existing point of contact, and Theranos has provided non-information, tangential, deflective or evasive answers to a written set of technical due diligence questions. The report would be heavily redacted, however, and only parts of its first page would actually be allowed in front of the jurors, and the whole document itself introduced as a demonstrative. Juror dismissal. Apparently, one juror during the trial had found time to play Sudoku and kept the puzzle hidden in their juror's notebook. Although they said to Judge Davila they had been able to follow the court proceedings, he dismissed her and another alternate took her place. Apparently, another juror actually told the court deputy about this. She claimed that she'd played the game to control her fidgeting, but that I haven't missed any testimony at all. There are now only 2 alternate jurors left. Shane Webber. Also on Friday we heard from Dr. Shane Webber. He was the one who authorised the Pfizer report that was critical of Theranos. He worked with Theranos on a trial of cancer patients who had Theranos devices in their home and sent blood samples back to Theranos for testing. Apparently there were huge variations in the results of the testing, and Webber sent that he'd spent nearly an hour with Holmes trying to understand the results and what Theranos would be doing in the long term beyond the cancer patient study. Theranos provided non-informative, tangential, deflective or evasive answers, he concluded in the report. He did say that they would keep in touch twice yearly, but that Pfizer never changed its mind on Theranos. And when he told Holmes that they would not be progressing with a partnership, she pushed back, but he was firm. She actually asked him for other contacts at Pfizer that she could approach, but he declined to provide them, saying that it would be a poor use of Pfizer resources. His supervisors had actually agreed with his decision. Remember that about a year later, a Pfizer report turned up, including their logo, etc., and appearing to validate Theranos devices. It is this document that the prosecution is claiming was forged. We then heard a recorded call between Theranos and the Hall Group, and in that call Holmes made a number of claims, convincing Brian Tolbert, a VP of the investment company, to make a second investment in Theranos. Through Black Diamond Ventures, the Hall Group had already indirectly invested, and they then invested another $4.9 million directly in December 2013. And if you're wondering where you've heard that name before, it's here on the list of investors that is included in the indictment. In the recording, Holmes made the claim that Theranos had the ability to run any combination of lab tests on a finger prick of blood. Let's hear it for ourselves.
Like, for example, the ability to use the cloud to control a health device, or the ability to run any combination of lab tests on these distributed devices. It would take us a long time to be able to establish an infrastructure that could do any lab test that is run in a traditional lab from a microsample, or these tiny droplets that we take now from the finger.
She also claimed that Theranos were doing work in the Middle East with the military and working with the US Special Operations Command. And let's hear that as well.
In terms of the military aspect of this, military is a big deal for us. And I can tell you confidentially a couple of the areas in which we've been focused there. One, in the context of work in the Middle East, and specifically in Afghanistan, the survival rate of our men and women in field when they're hit is 98% if they get through the doors of an emergency room within 60 minutes from the point of injury. And if we miss that window, that's where the bulk of our fatalities occur. And so the ability to take a technology like this and put it in flight, specifically on a medevac, has the potential to change survival rates. We will proceed with the pharmaceutical and military business, leveraging some of this infrastructure and the resources from it that we're building out now, so that for the long term will be an important thing for us. And what it does is it makes it possible to begin transfusion and stabilization in flight. And so we've been doing a lot of work there. We've also been doing a lot of work for Special Operations Command in the context of missions in remote areas where not only is there no capability to do testing for certain things that need to be measured, but if situations arise in which those tests are warranted, the mission is aborted and people are evacuated, generally out of continent now, so that for the long term will be an important thing for us. And it's also very symbolic because it's our way of being able to help make a difference in whatever small way we can. And we thus built the business around our partnerships with pharmaceutical companies and our contracts with the military.
Financial information from Theranos was presented to the court showing it would become profitable by 2006, and then conduct an IPO in 2008. Now, an IPO is an initial public offering where the company's shares would be sold to the general public and then typically listed on one or more stock exchanges. This financial information showed that the company had a valuation of approximately $1 billion, and we know that the company's valuation eventually got to $9 billion. And let's hear some of that from Holmes herself.
Now the valuation of the company is just over $7 billion, and that's at the $75 a share.
Needless to say, none of these forecasts or valuations ever actually came to fruition. We also heard that Chris Lucas, who introduced the Hall Group to Theranos, was paid $125,000 commission as a result. Now, Chris Lucas is the nephew of Donald Lucas, who at one point was chairman of Theranos directors and an early investor in the company. This involvement factored into Hall Group's decision to invest, said Talbot. As usual, we'll try to condense the whole week down to the bare essentials. We had Sunil Dhawan, who is a contact of Bhawani's and was paid $5,000 a month for being the lab director. He did very little work, as far as we can tell, and he didn't actually know that he wasn't the lab director. And he was asked to come in on a Saturday to sign many documents in advance of an audit. Daniel Eddin. Daniel curated visits around the lab to avoid visitors seeing parts of the building. He testified that Theranos devices were never used for patients. He testified about problems with the military relationship, for example, the working temperatures in which the Edison devices were supposed to be maintained while working. He also testified that Bhawani deferred to Holmes during the meetings in which he saw them. The document. We had some wrangling over the document which was by Pfizer and which was very damning of Theranos, and this was eventually partially allowed in front of the jurors. And to our mind, this is all foreshadowing the production of the forged Pfizer document, which turned up about a year later. We had the investor call, where the Hall Group were convinced by Holmes to invest in the company, and this was for $4.9 million, which we've seen in the indictment. Holmes made claims in that call that Theranos had the ability to run any combination of lab tests on a tiny fingerprint of blood. The venous draws of blood were not needed with Theranos technology, and also that Theranos were doing work in the Middle East with the military working with the US Special Operations Command. And no week would be complete unless we had one or more texts from Holmes and or Bhawani. In this case, I think we have some messages where their relationship was ending. These were in 2015, July. Bhawani to Holmes, I am sad at where you and I are. Bhawani to Holmes again, you need me. And a response from Holmes saying, it's just hard to transition. Was emotional, but I am ready. Well, that's it for the week. Wasn't it a busy one? Please don't forget these are all prosecution witnesses still at the moment, and thanks for watching. Please don't forget to like, subscribe and hit the notification button so you don't miss out on future videos when they are published.